This video is about judicial review and how it brings fairness in legislation. We all know that for a country, its constitution is its supreme law. And there will be some other documents like statutes, delegated legislation, and ordinance, which may use this constitution as a source to prepare all these documents. And once the court finds that these documents are not with the provisions of the Constitution, they may declare it as unconstitutional. And we have to know that the judicial review power is vested upon the judicial bodies of a nation. And these judicial bodies most probably will be the courts or the tribunals constituted by any central acts. And this judicial body will be the legal framework of any democratic country. And these judicial bodies plays a very critical role, like they play like a guardian to upgrade the values enriched to the constitution by their founders. And we can say that this judicial review mainly evaluates three aspects. That is, they are the judicial review of legislative action, and judicial review of judicial decisions, and judicial review of administrative actions. Now we will look amending power and interpretation. Who has the amending power? Well, we all know that as per Article 368, the Indian Parliament has the amending power to make any amendment in our fundamental law of the land, that is Constitution. And interpretation, that is absolutely the role played by the judiciary. The judicial or the legal framework of India has the power to interpret the provisions of the Constitution. So now we will find out how both these organs, the legislature and judiciary, how they work together. So first we will find out what is a constitutional amendment. We can say it as if we made any small modification, or if we add something more into the constitution, or we've taken it something from it, or made any subtraction from the constitution, we can call all these processes our constitutional amendment. And once a constitution amendment is made, it will have both wider and narrower implication. And we know that the judiciary is cross-checking each and every constitutional amendments to find out whether they are affecting the basic structure of the constitution. So while exercising the power of judicial review, the judiciary will first check out the principle whether the legislature is competent to make that constitutional amendment or any law. So this principle is also known as principle of pith and substance. And we all know that India has a written constitution, and three main organs it has, and they are legislature, executive, and judiciary. And the lawmaking party is performing by the legislature, and judicial review part will be performed by the judiciary. So, when the lawmaking body, that's the legislature, makes any law, the judiciary will exercise its judicial power and will cross-check it whether it is inconsistent with the super law of the land, that is the constitution. And the judiciary also check it out whether the legislature has used its power beyond the limit provided by the constitution. I mean, and if it finds that the legislature has exercised the power beyond its provided, then that law will be declared unconstitutional by the judiciary. And same time, the judiciary also check it out whether the legislative competency comes under which category, like whether it comes under the legislative power of the union or in the legislative power of the state. If it comes under the legislative power of the union, the parliament will be the lawmaking competent body, and if it is in state, each state legislature will be the competent body. And in this context, I cited one case law also, that is Chadurbai M. Patel and Union of India. And in this case, the Supreme Court has observed that the right of the legislature to legislate on any particular matter includes its powers to legislate on any auxiliary matter related with it. So the second principle is principle of severability. And while exercising the judicial review power, the judiciary will interpret the law, and it will find out whether the all part of the law or any part of the law is unconstitutional. And if it finds out that the all part of the law is unconstitutional, it will declare the entire law as ultra vires and void. And if it find out any part of the law is only bad or unconstitutional, that particular specific part itself will termed as unconstitutional, and the rest of the remaining part will be operative. The next principle is principle of progressive interpretation. What the term progressive interpretation means? There will in exercising a judicial review and interpreting a provision, the important question before the courts were like, should they interpret it according to the condition that prevailed at the time of making the law, or the court should interpret it in a more wider way according to the changing circumstances in social and economic life. And luckily, our judiciary in India, the judiciary is following a progressive way of interpretation. So the Supreme Court is not giving much importance to what the members said in Constituent Assembly. Even they have an opinion that the speeches made in the Constituent Assembly itself not give much importance while doing the interpretation or performing the judicial review. The Supreme Court had expressed this view in many cases, like State of Travancore, Cochin and others versus Bombay Company, and then in Bella Banerjee case, and then in Senior Electric Inspector was Lakshmi Narayan Chopra. In all these cases, the Supreme Court had followed a view that see what speeches had made in the Constituent Assembly at the time of framing the Constitution, not need to give much importance to those speeches while interpreting a provisions. Since we are following the progressive way of interpretation, we should look forward and give much more importance to the changing situations in the social and economic life and the facts and circumstances of the case. Next principle in judicial review is primacy of the Constitution. And we all know that Part 3 of the Constitution deals with the fundamental rights. And there is a provision in Article 13 that, and Article 13 of the Constitution says that no law can prevail in the country which conflicts with the provisions of Part 3. That is, no law can prevail in the country which conflicts the fundamental rights guaranteed to the citizens by the Constitution. So, does it mean that this fundamental right is an absolute one? Not at all. There are reasonable restrictions, and these restrictions are based on morality, order, public health, and national security. While enacting the law itself, the legislature will impose this restriction on the law made, and at the same time there will be no restriction in the enjoyment of fundamental rights. There will be some reasonable restrictions on the basis of morality, order, public health, and national security, and all these reasonable restrictions will impose on the law at the time of enacting the law itself by the legislature. At the same time, the courts have a duty that they should review these enactments and just cross-check it whether these enactments are inconsistent with the provisions provided in Part 3. Then comes the principle, the spirit of the Constitution. What does it mean by the spirit of the Constitution? Yes, finding out the inner meaning in between the words written on the Constitution. See, we all know that our Constitution is a well-written one. So there are difference of opinion. Should we follow the spirit of the Constitution or should go for the words written on it? There are different opinions on landmark cases. In A.K. Gopalan's case, that time Chief Justice Kanaya has observed that a court cannot declare a law as an invalid one if the law is against the spirit of the Constitution. According to the Chief Justice, just follow the words written on the Constitution and find out whether a law is valid one or not valid. Don't go to the spirit of the Constitution. But in practicality, almost all the learned judges are giving much importance or significance to find out what is the inner meaning in between the words written on the Constitution. That means they are giving significance to find out the spirit of the Constitution. Even we can say that it leads to the establishment of doctrine of basic structure. But at the same time, it's a fact that the court cannot go against the letters written on the Constitution. Now comes the prospective overruling. Actually, we can say that this principle was laid down in the landmark case in Golaknath versus State of Punjab. And this principle actually means that once a law is declared as invalid, it should not affect the transactions or vested rights before making it invalid. But it should be operative for the transactions and vested rights after the judicial invalidation. Actually, the purpose is that the intention or the objective behind this principle is that it's better not to disturb the past transactions and do better or make an effective law for the future transactions. Normally, there is a practice that the court will reluctant to reverse its previous decisions, but actually when we look into it, it's actually a violation of rights. For the sake of the people, it's the duty of the courts to make law effective, or if it need to reverse its precedents, or they should do it at the earliest. And we can say that the same happened in Shankari Prasad case. In Shankari Prasad's case, the court said that as per Article 368, the Parliament can amend the Constitution, and this power includes even to amend the fundamental rights. But in Golaknath case, the Supreme Court reversed this decision and said that yes, the Parliament can amend the Constitution as per Article 368, but it cannot amend the fundamental rights which are guaranteed by the Constitution in Part 3 to the ordinary people or ordinary citizens. The very next thing while exercising the judicial review, what the judiciary will follow is the presumption that the whatever presumption the the courts will assume, it always will be in favor of the constitutionality of the law. Before declaring a law as an unconstitutional one, the court will clear all its doubt about that particular law. Then only it will declare that particular law as an unconstitutional one. Because the assumption is that legislature is the lawmaking body and it is their right or it is their obligation to make any law, and that should be a validate one in accordance to the provisions of the Constitution. Means the way enacting a law, the intention of the legislature should be that it should understand and appreciate the people's needs, and at the same time it should respect all the provisions mentioned in the Constitution. There are various cases related with this. The very first one is the Chiranjit Lal Chaudhary versus Union of India, then F.N. Bulsara versus State of Bombay, then Hamdard Dwarkana versus Union of India. In all these cases, Supreme Court held that the presumption should always be in favor of the constitutionality of the law. Then comes the non-application of foreign principles. Yes, of course, in our country, our judiciary are not bound to follow foreign presidents while exercising the power of judicial review, because it's well explained in A.K. Gopal's case that we should not read the concept of due process of law, which is a foreign element, in with our procedures established by law, because what the court held is that it would be inappropriate to interpret our constitutional provisions in accordance with another country's constitutions, because the situations would be different, the language, even the political condition, all will be different. So it is inappropriate to read one constitution or the element following in one constitution with the other country's constitution. So comes determining the locus standi, principle of locus standi. While fixing the locus standi, the courts will have difference of opinion that it mainly depends upon the nature and the relief seeking for, or from case to case, it will be different. The basic principle the courts will be following is that if the applicant has any personal or significant interest on the result of the application, then his locus standi will be accepted. If the applicant has no any personal or significant interest on the result, his application will not be entertained by the courts, even if his prayer was a clear prima facie violation of law. Then comes the last one, the very important one, the theory of basic structure. It was in Golaknath case, the constitutional amendment 24th and 25th constitutional amendments were challenged, and it was decided by a full bench of Supreme Court, that means 13 judges, and the case was determined by a majority of 7:6 ratio, and the case held that the Parliament can amend the Constitution according to Article 368, but the Supreme Court imposed a new theory, that was the theory of basic structure. And then the court held, according to this theory, the Parliament can amend the Constitution, but including the fundamental rights, but no the basic structure of the Constitution. This